Good evening, this is Rahul Reddy live here from Houston, Texas. Every Tuesday at 5 p.m. Reddy Neumann PC brings in business immigration news. Emily, now a little known thing, but it seems to be a very serious matter, is that the Trump is coming with a second executive order. Not much press has been covered. What is this about? Is he taking the emergency provisions and suspending all the regulatory things? Can you explain what a regulation is, what a law is, what an executive order is, and under what circumstances Trump can do it, and what do you expect from this new executive orders that is expected to come?
Right, so Trump basically gets his powers to act from the Constitution, or when Congress passes a law, they can provide specific powers to the president or one of his government agencies as part of the statute passed by Congress. So those are the areas where really is limited to acting on. Now, when we had the executive order on restricting immigrant visas about a month ago, that power was under power provided by Congress in the Immigration and Naturalization Act that allowed the president to suspend entry of certain people for limited purposes for a limited period of time. Other than that, the Trump administration is also in charge of government agencies that are implementing the laws, and they do this through the regulatory process. So the administration also has the power to make changes in law based by changing the regulations, but that is not a quick and easy process. It normally has to go through a notice and comment period, get the public comments on what they're proposing, review all of that, and then come up with a final regulation, give advance notice to everyone of what the new rules are going to be. It's not something that typically can be done overnight. So with the immigrant visa restrictions that were through the executive order, that was power given to him by Congress when they passed the INA, and it allows him to suspend entry. So he used that to block immigrant visas, but also there's a very good chance that he could use that same power to block certain non-immigrant visas. What types of visas do you think he'll be looking at?
Before the executive order was being issued, we did projected that he may put some restrictions on the work visa, especially traveling though. That is what we expected. However, though, in the executive order, when he issued though, he did put a restriction. That was in April 26, I believe, exactly 30 days ago. He did put a restriction on the immigrant visas issued to the family preferences exactly 30 days ago. And then he did said that in 30 days, the administration should come up, the agencies should come up with regards to the policies that can bypass the regulatory provisions. 30 days ago, he wanted the things what can be done by the administration. And on May 19th, the executive order, though, that is been issued on May 19th, where he's requesting the agencies to see what all the regulatory procedures that they can bypass it so that they can expedite either the regulations or probably issue the executive orders suspending the existing regulations, adding the new regulations, or making some changes to the existing regulations. I think so that he may restrict some of the work visa people entering into United States. That's what I'm projecting though. Previous to the executive order, we did projected that he may issue a temporary order which might bar some people entering into United States for a temporary period of time. He only did that for the immigrant people though. However, this time though, he may go and say that H1Bs, L1s, in some cases the student visa people and also some J visa people that are working, he may put some restrictions on them coming into United States. I'm expecting those kind of things to come into United States, the restrictions. So what do you think, Emily? I mean, are they going to be broader changes or just only entering into United States though?
Yeah, I think that first it will be restricting entry into the U.S. for those that are currently outside the U.S. I feel like kind of the usual way the Trump administration goes about these things is they talk about all of the huge ideas that they want to implement and kind of leak all of that to the press. The press has a field day with it. They start talking about it and saying, Trump says he's going to do this, he says he's going to do that, he's going to stop OPT, he's going to block people coming from China, he's going to stop J1s, he's going to stop H1s, L1s, and all these things. And then they see how the public reacts to that, see how businesses react to that, look at what the legal implications are. Can they legally do those things? And then come up with an actual final executive order, which is much more narrow than what we all expected. I mean, that's exactly what happened last time around when he tweets in the middle of the night that we're going to ban all immigration. And then when the order actually comes out, it was quite narrow. So I think we're going to be looking at the same kind of thing. We might see more long-term changes going through the regulatory process to create some additional restrictions on OPT, for example, or some new restrictions on LCA details that have to be taken care of for H1B workers. But I think those are more long-term. I think with this actual order, it's more going to be blocking travel into the U.S.
Travel into the United States, that's what I'm assuming. For the people who are in USA, we are not expecting any more restrictions, at least in the form of the executive order. Is it right, Emily?
That would be my prediction.
That would be our prediction too. Emily, with regards to the H1B L1 reform bill that is proposed, what's going on? I mean, is there a bill on the Congress right now? What are the chances? Do you give any serious thought about this?
Yeah, the reason why I wanted to talk about this is to let people know, yes, we're talking a lot about immigration in the public right now and with everything going on with this pandemic, but this particular bill, the H1B and L1 Reform Act, was introduced into the House. It has been introduced practically every year since 2009. The exact same bill by the same sponsors every year. So it's not really something to take that seriously. It never goes anywhere. There's not a lot of support for it. I think we're in the same situation here that yes, they did propose it, but it's the same thing they propose every time that ends up going nowhere. So I wouldn't be too concerned.
But what about this Healthcare Resilient Act? Is it the same thing? It goes nowhere or it normally has a higher chance?
I think this has the Healthcare Act does have a higher chance because it's more bipartisan. They're adding more co-sponsors to it every single day. And it's something that's targeted specifically to this situation versus a bill where they just want to, restrict H and L visas by the same people who want less immigration and to restrict it every year for the last 10 years.
Emily, H1B lottery system, are we getting the receipt notices? Have we started getting any approvals though?
Yeah, so we could start filing between April 1st and June 30th. So this filing window is still open for those that were selected this year. We started filing in early April. We're continuing to file cases for our firm's clients, but we have started receiving receipt notices. We've actually also started receiving approval notices, some in as little as 2 weeks. So processing looks good this year, seems to be a lot easier. I will say the receipt notices from the Vermont Service Center do seem to be much more delayed compared to what's going on at the California Service Center.
Emily, the public charge rule has created a big problem with the immigrant community, especially in the COVID situation. A lot of people ask this question, especially our audiences, the family income is at least more than $80,000 for most of the family income whose family income is more than $80,000. So I'm going to ask you a couple of questions though. This public charge rule, where the family income is more than $80,000. If they have a house mortgage, will they have any problem in getting the green cards or H1B?
No.
Did you say no?
No.
If they have a student loan or in the back in the country where they came from, will that cause any problem in getting the green card or getting the H1B or anything?
No, it should not be considered a public charge.
If they have any credit card payments that are due, I mean, like if there's a $7,000 payment, they did only $500 minimum payment, whatever is required, and they have some credit card due, will they have any problem in getting the H1B and also green card application?
No, I don't think so.
So why do you think that this public charge is, why is it overrated when it's applicable to the business immigrants though?
Yeah, I mean, exactly. The whole point of this public charge rule was to ensure that immigrants don't end up using public benefits or going on welfare in the United States. It's been the rule for years and years and years, but now that we are adding new questions on the forms, it's being looked at for filing an extension of status or a change of status with the USCIS, which it never was before. And there's just a lot of information, a lot of people talking about it. So I think the social media makes everything seem like it's a bigger deal than what it actually is. For the most part, those that are being sponsored for employment-based green cards, generally, I don't think there's going to be much of a impact of the public charge rule.
Please note that there are a lot of people that have used the government benefits. Their family incomes might fall below $40,000. They may be impacted with this public charge bill though. But normally for the family income of $80,000 plus, we are not expecting any problem. I haven't seen it. I do file adjustment of status cases. We're not expecting much problem. Emily, comments are coming on Ken Trump administration. This is from Subramaniam is asking, can he suspend the H1B extensions for a year?
I don't think he has the power to do that at all.
Most probably we may be expecting Subramania only to have some suspension for a temporary period of time, whether it's 60 days, 90 days, or for the people who are stuck outside the country to enter into the country though. When I looked into the executive orders that was issued on May 19th, it is executive order on regulatory relief to support economic recovery. So I don't think so. I mean, with the unemployment rate, which is actually less in the computer profession though, and most of the H1Bs are given to the software profession. So I don't think so that he has authority. That's my opinion too. Mostly only travel restrictions where the person goes outside the country to come back. There may be some restrictions. That's what we're expecting. Let's go to questions, Emily. Any news on the H4 EAD? Nothing is going on at the H4 EAD right now. Nothing is going on at the H4 EAD right now. So things are as usual. However, we are seeing a delayed H4 EAD adjudications right now, especially with the fingerprints getting blocked up. They are not approving any H4s where the biometrics have not been done. Srikanth asked this question from Facebook. Hey, can you comment anything on the USCIS IT Sub Alliance? This is an out-of-court settlement where the USCIS has completely taken back the memos that it has been issued. These are the orders that were been issued by the USCIS that they have taken it back because of the court litigation. What they have is that in the January 10th of 2010, I may be a little bit off on the date, and also February 8th of 2018 memo, they have decided to take back. They were asking the end client letter, they were asking the contract, especially in February 8th, 2018 memo, they were asking the contracts between the end client and vendor. The MSAs between the end client and vendor. A lot of information that they're asking. They decided that they are not going to use the memo principle. They are not going to use the common law principle. They are going to go to the regulations and implement the regulations rather than actually implementing the memos that the USCIS have issued. They have withdrawn. They promised to withdraw the memos soon. So this is a good victory, especially for the consulting companies. The consulting companies have a lot of employees working at different locations other than their own location, and that has become a very big thorn, especially starting from 2010 onwards. We had big problems. Right now with the settlement, we are expecting a little bit more cleaner approvals than that of the previous one. We were also getting the short-term approvals where they didn't used to give any explanation. They just used to approve for 1 year, for 2 years. They have agreed that if by any chance that they're giving any approvals which is shorter than the time period that we're requesting, the USCIS said that in this agreement, if they would give any short approvals then the employer is asking for, they would give an explanation why they are giving a shorter approval than the requested period of time.
Swati from YouTube wants to know regarding the H4 EAD whether USCIS is reusing or waiving the biometrics requirement for the H4 extension, the I-539 application. So there is an update on their website that says that they will reuse biometrics if they've been previously provided. However, not very many people for the H4 EAD renewal fall under that category where they've previously provided the biometrics in a previous I-539 application, because that only came into play about a year ago. So most people are not filing their second H4 extension at this point unless there's a transfer situation or something like that. But for others who maybe 3 years ago filed their H4 and EAD and now they're doing their renewal, well, 3 years ago there was no biometrics requirement, so you likely didn't have it done. So I don't think there's anything for them to reuse. So I think it doesn't really help as many people as what we would have liked.
One question is that, are there any pitfalls of the cap exempt H1B visas? Resham is asking from YouTube. Yes, there are some small pitfalls, particularly if you take the job. Let's say you are in STEM extension, and let's say you are moving into a cap exempt H1B. From that cap exempt H1B, if you want to move to a regular for-profit company, then you have to go through the lottery system. So you will be handicapped, especially when you don't have a work permit to work for them and they have to wait for 6 months period. They may not be willing to wait. So between choosing a cap exempt and choosing a cap subject, I would always like to get a H1B approval from the cap subject. I would only go for cap exempt when I have no option, when my time is expiring and STEM extension, there's no more period left. I would not go to the cap exempt unless you're expiring the 3 years of the STEM extension, or in some cases on OPT only where STEM extension is not eligible. That is the general feeling. Of course, you may look into other aspects also. Is the job better? I'm not deciding on that. You're a better judge on which job is better. But as far as the immigration is concerned, I would like to go with cap subject rather than cap exempt H1Bs.
Sanskriti from Facebook says that USCIS erroneously returned the I-140 petition on May 15th because it was not filed with the original labor certification, even though they said that they would issue electronic copies and they would accept those at USCIS. So when resubmitting, you're wanting to know if you can expedite the application, as USCIS error is one ground of expediting. Probably not. I mean, you can try. There's no harm, or really it would be your employer that would try that expedite request because it's the employer's petition. But here, yes, it was a USCIS error. Yes, we have seen that as well, and we're resubmitting the I-140 petitions with notes of, a printout from the USCIS website saying that you're supposed to accept these. And we're asking that the original filing date be honored, but to go beyond that and ask for an expedite when maybe 1 or 2 weeks' time has been lost they might not accept that as a reason to expedite, even though it was their mistake, but there's no harm in trying.
YouTube question comes, how long it's taking for a PERM processing nowadays? We're noticing the cases that we filed in the December last week and January first week. This is most cases though. I still see some cases that were filed in December first week also still getting approved, and also in January last week also. But more or less it's at December last week and January first week is what is the time that it is taking for the cases that were filed in the PERM though. Raj asked this question, can I work for 2 different employers under for the H1B, two different employers filing 2 H1Bs? Yes, Raj, you can work for 2 different employers, but the second employer must file something called a concurrent H1B filing. If he files, you can work for 2 different companies, absolutely no problem. Can you work 2 40 hours? You can, yes. I know a lot of people who work 2 full-time jobs. I salute them, we need their taxes. Yeah, you can. You can file a H1B, you can file a concurrent filing. Now, the third question is, when the when he files the concurrent H1B filing, does he have to wait for the concurrent H1B filing to be approved, or once it's filed, he can start working? You can start working when it's been filed. You don't have to wait for that concurrent H1B to be approved.
A couple of people have asked if we can expect any STEM OPT or OPT changes upcoming. That definitely has been something talked about in the media a lot. It's something that I think the administration would like to do. Whether they have the power to do that through an executive order is a different issue, and I don't think they have the power to issue an executive order that suspends OPT or changes OPT. Maybe they can suspend entry of people on F1 that are using OPT and coming into work. That's a possibility. More likely is they're going to issue new regulations, which we've known about for some time. It's been on the regulatory agenda that they want to propose new regulations to modify the STEM OPT program so that there's more oversight and probably restrict it more. But that has to go through the regulatory process. I don't think it's something that's going to happen through executive order overnight.
Manoj has this question. His I-797 is expiring on July 1st, 2020. I-94 is expiring on July 11th. And this I-797 is a 6th-year period. Now his I-140 is pending. What are the options? Right now, because the travel is very restricted, and even if the restrictions have been lifted out, you may not want to endanger yourself in traveling with all the people in there and breathing the same air of some of the people who are COVID patients there. So I would recommend you may want to file a B2 application. I may want you to actually stop working, not from July 1st, but actually on May 25th. Sorry, not May 25th, June 25th itself, to leave a 1-week gap. I would request that you consult a lawyer to plan all these things so that you can get from H1 to B1. However, Manoj, though, once you apply for the B1, if you're planning to think that you will get back to H1B while in United States, that is most probably cannot be achieved. The better option would be that because of the COVID restrictions, you're not traveling outside the country. You may apply for the B2, but if in the interim period your I-140 gets approved, you can apply the H1B, but not as a change of status from B2 to H1, but as a consular processes. That is more advisable because they won't approve the H1B until the B2 is approved, and B2 will take a long time for it to be adjudicated. So file a B2, exit the country, and once the I-140 is there, you can apply for the H1B. And while you are in the country, and if you still, I-140 is approved, you can do the consular processing. That would be a better option for you.
Jitendra from YouTube has spent 114 days outside the U.S. while on L1 status so far and wants to know if that time can be recaptured during an extension. Yes. Both H and L, they're subject to either the 5, 6, or 7-year limit, and both of them allow you to recapture any time spent outside the U.S. so that you don't actually reach that 5, 6, or 7-year limit. Rahul from YouTube also wants to know, with a potential executive order coming out on the non-immigrant visas, should you be worried about an H1B cap subject petition getting filed this week? Can filing the petition be suspended? I don't think you need to worry about that. Based on our analysis, I don't think the Trump administration or President Trump has the power through executive order to block people from filing petitions with USCIS. If you are requesting consular processing of that petition, that's where you might be impacted. You might get the approval, but then you might not be able to travel to be able to get the visa stamp to come back. But change of status petitions, we don't think should be impacted. Can one do a permanent remote job while on H1B? Yes, you can do the whole 3 years of your H1B, you can do a remote job. Absolutely not a problem. I normally, when I recommend people to, when you file a H1B, try to include both employer, the end client or location where your actual work takes place, and your apartment where you are. But is it necessary to have the work location or can you just put your apartment or your home where you're going to work for the next 3 years? Absolutely nothing wrong. You can work from your home
all 3 years, perfectly legal, no problem with it.
SBK from YouTube completed a master's degree online from an accredited university and wants to know if he'll be able to file in the master's quota next time around when it's time. So an online school can qualify under the master's quota. It requires the degree to be accredited, and it must be a nonprofit or public university. So if those requirements are met, even if it's an online degree, the degree does qualify for the master's cap.
Piyush has this question, do you expect the executive order to affect the people who are in the United States? Piyush from Facebook, we are not expecting, also I believe in April 21st, before the executive order came in, we did projected that we are not expecting any restrictions on the H1B with the executive order, those people who are living in United States. We may be expecting people who are entering into United States, but not the people who are in United States, we're not expecting.
Pratap from YouTube wants to know if e-filing is available for an I-140 submission or if hard copy filing is required. So they used to have e-filing of the I-140 many, many years ago. That was suspended. So as of now, the I-140 does have to be filed hard copy to USCIS.
Any comments on the employment-based GC interview timeline waiver process? Akshada has this question from YouTube. At this point of time, until June 4th for sure, there are no appointments, no interviews that are getting done. We are expecting the administration to open up starting from June 4th, but we yet don't know if they're going to postpone it, if they will make any changes to that, we don't know. They will have to see that. With regards to the waiver though, at this point of time, we have no comments from the USCIS that they are going to grant waivers for the interview process for the employment-based immigration. We are not expecting, at least nothing is there in the pipeline that we can think that they're going to waive the employment-based immigration green card interviews.
A couple questions again about the executive order and the impact on upcoming filings. So if someone needs to apply for an extension right now, do you think that the Trump executive order will block them from filing their extension for an H1?
While they are in USA? No, we're not expecting that the extension, if they are in USA, will have any problem. We do expect though, if the people go outside the country, there may be restriction in traveling back. There may be some restrictions on giving the visas outside the country, and that too only temporary is what I'm expecting though.
Aryan from Facebook wants to know if there's going to be a second lottery for H1Bs this year. You know, a lot of people have asked that question just because of the current economic situation. But our experience is that those that have been selected in the initial lottery, those companies are filing. Very few of them have dropped out, so the economic issue has not been an issue for many of the H1B employers. So I think they're still going to fill the lottery based on those that they've selected so far. I don't think there's much chance for a second lottery to be conducted.
Balaji has this question that H1B extension is in process. How long can he work outside USA? Well, Balaji, if you're outside USA, you're not under US jurisdiction. I'm assuming that you may be in India. If you're in India, you are an Indian citizen. An Indian citizen can work in India. There is no limitation, none whatsoever at all. As far as the process is concerned, yeah, it is taking a long time. But even if the process gets denied, you can sit down in India and continue working there. A lot of people are under the assumption that to work in United States remotely from their home country, they would require some non-immigrant visas. I'm very surprised what kind of questions that come up. No, if you are in your home country and you are remotely working into United States, you do not need any work permit, none whatsoever at all. The immigration doesn't come into picture at all if you're remotely working from your home country. No, you can work, it's perfectly legal, you can receive the money from your company The taxation and other things, I would let the CPAs handle it, or chartered accountants handle it, but as far as the immigration laws are concerned, they don't come into picture. You can sit in your home country and work however long you want to.
Vikas from YouTube has an L1 expiring in November and wants to know what the best time is for filing the extension. So I'm of the opinion that it's better to file the extension earlier so that you can get the result before your current I-94 expires. So you can file it up to 180 days before the expiration date. Some others might be of the opinion that let's file it as late as possible so I can get some added work authorization for up to 240 days. But that's very risky if there's a possibility of your extension being denied. If you decide to file later and the case is pending after your I-94 expires and then gets denied, you're immediately out of status and accruing unlawful presence. It's very difficult to take any action from that point to stay in the country. Compare that to someone who files early, and let's say in October they get a denial. Well, their current visa is still valid till November. They're still maintaining status. They're not unlawfully present, so they can use any other option available to either refile that extension or file a change of status to some other type of visa without having to worry about unlawful presence or being out of status.
Saranya's I-140 has been approved under EB1C, and her priority date is not current, and she is at the max out of the L1A. She's going back to India. What are the chances of getting a new L1A from India? One, you have to wait for at least 1 year. You must work in the overseas operation at a multinational executive position again for over a 1 year period before you apply for L1A again. You need that 1 year outside the country presence before you come back into the United States. Just because you have an I-140 approval, it will not impact, none whatsoever at all, your L1A application when you're trying to come back into the country. It will not help you, it will not harm you. L1 is a dual intent visa. So if you have an intention to immigrate into the United States, the consulate officers will not deny your L1A. That's the basic. Now, with regards to the L1A approval, merit basis, whether or not it's approval is a different question. But as far as the I-140 is concerned, you will not have any advantage or disadvantage in getting L1A. Emily, I need your help on answering this question, though. Mehul is working on one project for one company. He's getting another project for the same company, assuming the other project is also in the similar lines. Does he need to file any amendment to work for both projects for one company?
I don't see any reason to if the work location isn't changing.
Yeah, I don't see any reason, Mehul, also, if the work location is not changing and you are working for two projects, we don't see any reason at all. Maybe if the pay scale increases very significantly, yeah, you may want to file an amendment to be on a better picture. But if the pay scale is not improving, that's fine. If the pay scale is improving significantly, which I feel maybe you do, you can throw an amendment out there, and you don't have to wait for the amendment to be approved to work for a different, to wait. You can have two projects, you can work for 80 hours too, there's nothing wrong with it, and get paid. Please pay taxes, we need that.
Vinny from Facebook wants to know if a company can do a salary cut for someone who's on H1B. So there's two issues that could come up. The first is the company always has to pay at least the prevailing wage for the type of position in the location. And so if that salary cut is going to reduce your pay below the prevailing wage, then it's not possible at all. Secondly, if the cut is still meeting the prevailing wage requirement, a cut in salary is likely to be considered a material change in employment, and a material change always requires an amendment to be filed before the change can take place. So if the prevailing wage will still be met even with this salary cut, they do still need to file an amendment with USCIS before taking that action.
This question is coming out, Emily, is when are the US consulates opening in India? When are the consulates opening? They are supposed to open in June 4th. At this point of time, though, what I noticed was that the people who have had appointments in the June second week, actually they got their, they haven't been canceled at this point of time in Canada though. When people are trying to book appointments in Canada or Mexico, the openings we see is in October, but the things what I see in India, actually, they're all in February of 2020 and not before that though. Mm-hmm. We do expect that there might be more openings, especially for the student visa people if you're applying for it. There might be more openings that may be popping out when the officers start, opening up their schedules. It may be even though it says it's February, it's not available. The next 1 week there might be something in July. There might be something available in June. At this point of time, we are noticing that in Canada it's in October, and in India it's in February's appointment timing. But the Trump administration does want to open the consulates pretty soon. We may be expecting sooner, but can I give a particular deadline? Can I give a particular date? No, I cannot at this point of time. That requires to be an expert on COVID, which doesn't look like I am.
Shabir from Facebook wants to know if people already with an approved H1B but without the stamp and are stuck outside the country will be impacted by a potential executive order. I do think that is the most likely possibility. Again, the president's power is he has the power to suspend the entry of certain individuals as long as there's a valid reason for it, a set time period for it, and it's targeted to specific groups of people. So it's very likely that if you don't have a visa stamp already, he could suspend entry for people who would be coming in non-immigrant visa work categories such as the H1B.
Questions from Nilesh is that he's trying to get the L1A extension by doing the consular processing. Most probably he has a blanket L1 approval. That's what I'm assuming. His company has a blanket L1 approval. While this is going on, can he still submit the L1 and L2 plus EAD at the same time? So I'm a little bit confused about the things though here. If you are doing L1A extension in the consular processing, you cannot file L2 extension and EAD application in United States. But if you are doing L1 extension within United States, you can file for the L2 and EAD. If you don't club with the L1, if the L1 extension has never been filed, the L2 extension is not, they cannot file in USA.
Tejaswi from YouTube wants to know if it's true that USCIS is approving H1B petitions filed in the master's cap for this year's lottery. Yes, we started receiving approval notices last week for cases that were filed, that were selected in the lottery in April of 2020 and were filed after that. Some of them are being approved in as little as 2 weeks right now.
Anil has this question, are nonprofit organizations exempt from the premium processing suspension right now? No, they are not. The premium processing is still not available for nonprofit higher education. Vikram YouTube has this question. School teacher on H4 EAD, are they eligible to apply for the H1B or GC? What do they need to do it? One thing, you may have to check with a lawyer to see if the school might be eligible for the exemption of the visa numbers because they are a nonprofit. If they're affiliated with a higher education institution, they may be exempt in the H1B number. Yes, school teachers can file for H4. Those people who are on H4 EAD, they can file for H1. They can file for a green card too. Absolutely, you can. But whether or not the school qualifies for exempt H1B, I would recommend you consult a lawyer. If you want to do it in our office, the best person would be Crystal Alinas, and she is the one who takes care of these things in our office.
Jaya from Facebook says her husband's H1B approval was for 3 years with the new I-94, but when she checks the online CBP website, the I-94 has not been updated. How to update the I-94? get this question a lot. It's very common. The answer is you don't need the one from CBP. That one is only updated when you travel and you re-enter the country, because CBP is in charge of Border Patrol. They're the ones that issue that I-94 when you enter. But when you file an extension, that's with USCIS. That's actually a different agency under Homeland Security. And so the I-94 is attached to your I-797 approval notice. That I-94 attached to the approval notice takes the place of the one that you got online. You won't get them updated online until you go out and come in again.
Tej has this question. The premium processing case is taking longer than 2 weeks. It's been 50 days and still pending. Ooh, you can drop an email to the premium processing unit. If it's been pending for that long, there is not much you can do. They will refund you the money. You just drop an email to them, say, hey, it's been more than 30 days that you're pending, and they will refund the money. Unfortunately, you don't want the money. You want them to adjudicate, but there is a possibility that if it's such a long period of time, they will not abide by the time. They'll refund the money that you have paid.
Amit from YouTube had to reapply for the H4 EAD card because it was lost. Amit wants to know how long it will take and if you have to go for fingerprinting again. So if you just applied for the EAD card because the EAD was lost, you don't have to go for fingerprinting again. The fingerprinting is only required if you are extending the H4 or filing an I-539 application, but the processing time to get a new card is the same as the regular processing time. So it can take anywhere from, I'd say, 3 to 8 months, depending on which service center yours went to.
How long it's taking for the current B2 extension to be approved? It says that B2 extension is taking about, online it says between 6 to 8 months, but it may take even longer time. But my question is that, if you apply for a B2 extension though, you don't have to wait until the extension is approved. If you want to leave the country though, you can leave the country. It's not a restriction that since your B2 is pending that you cannot leave the country. Most probably that's what is going to happen, because B2 you only applied extension for 180 days or 6 months, and now it's taking more than 6 months. So either you file one more extension, which we do not recommend, or you leave the country. So most probably you don't have to wait for the extension to be approved. You can leave the country, you're fine. But make sure you keep the documentation that you applied for the B2 extension, because when you're going to try to come back next time, they may say that you stayed here without proper authorization and you never filed for an extension. Then you can show them that you did file the B2 extension. Here is a receipt notice, and they should be fine with that.
Ananda Raj from Facebook wants to know if an employer can file a PERM if he's outside the U.S. Yes, that is possible to do. Both the PERM and the I-140 do not require you to be physically in the U.S. to be sponsored. It's only when you get to the I-485 stage to file that you have to be in the U.S.
There are a lot of speculations with regards to who is going to be covered in this executive order, who is not. We made some projections in the early part of it. Don't construe that as the final thing. That is just the projections that we have. You can go back. A lot of questions are coming back, especially from the 1 minute to about 6 or 7 minutes that we covered the topic on it. I would want you guys to look into it, but don't take that as it's already been done. This is just our projection, what is expected. Once the executive order do come in, please log in. Every Tuesday we do bring in immigration news. We cover all the things, what you need to understand, what you need to know. So every Tuesday we'll be there for you guys to answer the questions and also present the things what are coming, what are expected, what are the projections that are going to be there. We are going to be doing it every week so that you be prepared what is coming in. That's the reason why we present. At this point of time, those are all projections, not yet done.
So speaking of that, do you think the executive order will have the possibility to rescind the H4 EAD?
It came under the regulations, the H4 EAD. Obviously, when I look into the executive order though, especially in the 4th section of the executive order issued on May 19th, the Trump administration is trying to use the coronavirus pandemic to try to see if we can get away from the regulatory agenda, which requires sometimes a couple of years, though, or sometimes from the minimum of about 3 months to and sometimes a couple of years to get those things done. Would he try to do H4 EAD? I highly suspect he would not be doing the H4 EAD. That's my projection. I highly suspect. I don't think so that he would be touching the H4 EAD in the executive order. Though I have to point out that this executive order that was passed on May 19th, though, have told the administration has requested all the agencies, including the Department of Labor and USCIS APP, to expedite the processings of the regulations. So H4 EAD is already on the menu of the regulatory agenda. So they may issue regulations on the H4 EAD, but at this point of time, I'm not suspecting that they are going to do anything on the H4 EAD in the executive order. They may do in the regulatory agenda, but not in the executive order. That's my projection. But you can differ if you want, Emily.
Oh, I agree with you. Viswanathan from YouTube wants to know if we can talk about H1Bs working full-time remotely or working from home. What are the issues involved with that? Is it higher scrutiny? What happens if you move? So it is possible to file an H1B petition for someone who's working from home full-time. No issues with that. There is a higher likelihood of a request for evidence asking how the employer-employee relationship will be maintained when you're not working physically in the same office as your employer, so you should be prepared for that type of RFE. And then, yes, you do bring up a good point. What happens if you move? If you move outside the metropolitan area or outside a normal commuting distance from where your home is currently located, let's say you move from Houston, Texas to New York City, New York, an amendment has to be filed for you to start working in New York. So a new LCA plus an amended petition to USCIS. But if you're moving from one suburb of Houston to another suburb of Houston, no amendment is required for that.
Emily, this question related to the discussion we had an hour ago, 2 hours ago. Anand Raj is asking the question that he filed a H1B on April 16th, and it's been 40 days, no receipt. Is that slow?
I would say if it is from Vermont, we are seeing a delay in getting receipt notices specifically from the Vermont Service Center. You said it was an extension or a cap case?
I don't know, he didn't say that, but it's 40 days that he hasn't received the receipt notice. What would you do if it's a cap case? Would you wait? I mean, what if you come near the June 30th though?
Yeah, I would definitely be taking action by June 30th if it's a cap case and you still don't have a receipt notice and the filing fee check hasn't been cashed.
I would file it again. Mm-hmm. Well, maybe risk losing the money, but I would file it again if it crosses by, if it's a cap case, I would do. Another thing, Anand, I may want you to check is to check with your lawyer or check with your employer to see if the check that was written for your H1B has been cashed. I mean, if it's been cashed, though, you can relax and you're good shape, though. When the H1B has been, when you get the receipt notice, though, they will have a date of when the USCIS received the application, when they're issuing the notice date. So it will be 40 days before when they issue the receipt notice. But yeah, there are some cases, particularly in Vermont Service Center, is where we are noticing the receipt notices are taking a longer period of time.
Anna Mendez from YouTube wants to know if there's any possibility of extending OPT due to COVID-19.
No.
I would not expect that at all. There's really been no relaxation of the rules for anyone due to the virus. So no, I would not expect that.
A lot of people are asking, B2 visas. We never encouraged B2 visa people to extend their visa status because, but however, normal circumstances, we never recommended people to apply for the B2. But this is not normal circumstances. Sky fell down. mean, there's no flights. You can't even fly. You need to pay some lakhs of rupees and then wait for the lottery to see if your name gets picked up. That's the only way to go to India right now. And the other way is swim from New York to Bombay. That's very unlikely, I guess. So under the current circumstances, though, yes, you could apply for the B2 extension. Please don't expect the B2 to be approved and then leave the country. That's not going to happen. While it's pending, just leave the country. You can do so online, B2 application though, but be careful if you're wanting to file, let's say if your mom and dad both are there and you want to file both of them, you cannot do one application for both the people when you're filing I-9. I don't know why they didn't do it, but they didn't provide that provision there. You will have to either apply 2 online applications or you have to apply I-539 manually and enclose that extra $85 for the second applicant biometrics that you need to get it done.
Devish from YouTube wants to know, what are the options to change employer while a spouse's H4 and H4 EAD renewal are in progress? So you can still change employer. So I'm assuming you recently got your H1B extension already approved and your spouse's H4 and EAD are still pending due to the long processing times and the lack of biometrics. You can go ahead and file the transfer. Although the H4 and the EAD are pending based on the H1B that you filed with your previous employer, the H4 is not actually tied to a specific employer. It's tied to your status. So as long as you're maintaining your H1 status either with that employer or the new employer, the H4 and EAD renewal can be approved. Just know that when you file your transfer, your approval notice is likely going to get extended for a longer period of time compared to the approval that your H4 spouse will receive. It will be cut short to what your last H1B extension was approved for. So if you want everybody to have the same end date, you could always file another H4 and EAD extension along with your transfer. No problem with doing that at all.
Is there a possibility to get the H1B petition approved while doing PhD? Yes, if you're doing a PhD and you can want to file a H1B, yes, you absolutely can file an H1B and get it approved. You don't have to have a PhD completed before you file a H1B. You can just file it while it's pending, while your PhD is pending. Absolutely, that's not a problem at all.
Apurva from Facebook says the prevailing wage for the green card process has been under process since November of 2019. The H-1B 6-year limit is coming up in May of 2021. Are they delaying the process due to COVID-19, or are the response times actually this long? So we have not seen a delay due to COVID-19. The response times on prevailing wages have been long for some time now. It's been taking almost 5 months. So there's nothing really unusual about that. And there's no extra delay that we're seeing due to COVID-19.
Is there any restriction for a nonprofit higher education institution to file a H1B? That's a question from Ashwin coming from. No, there's no restriction. They can file a H1B. I'm assuming nonprofit and higher education, they will be exempt from the H1B numbers right now. You can file a H1B. Right now, there is no restriction that you have to file only in March and file in between April to June. There's no restriction like that if it's a nonprofit and higher education institution.
Vishal from YouTube wants to know if we can transfer an H-1B to a new employer. This is a cap subject H-1B before October 1st, like in a situation where you've been laid off. So I generally recommend waiting to file a transfer right on October 1st. Because if you file it before October 1st, a few years ago, USCIS started denying the transfer, saying that you haven't actually been counted in the cap yet because your H-1B has not kicked in. So I generally try to wait until October 1st, file it right on October 1st, and then you can work through with the new employer, assuming that you are maintaining your F1 and OPT with the new employer prior to filing.
A question that came is that my lawyer has said that it's taking a long time for getting the PERM application filed. Why? That's a question that comes in. Yes, there is something called prevailing wages. They're taking a long period of time, almost 5 months right now. They used to take about anywhere between 70 to 90 days. They're taking 5 months right now. That is definitely causing a lot of problem in filing a PERM application faster than what it used to be. I mean, we're filing much later because we need to have that before we can do some other steps to file for the PERM labor certification.
Yeah, I think also, there's a couple of steps that the employer has to do, such as a notice of filing. It's a physical hard copy posting that the employer has to do at their office. Well, when everyone was under lockdown, the employer was not able to do that. That has to be done for 10 business days, plus wait 30 days before you can file. So that's caused some delays in cases. And yeah, that's another issue that's been coming up.
Does concurrent H1B, can you file after the H1 validity? If you have an H1B extension pending, or if you have a transfer of the H1B pending, and that transfer and extension has been filed before your I-94 expired, I don't see any reason why you can't file a second concurrent filing with a second company and work for 2 companies at the same time. But please note that other application, whether it's an extension or transfer, must have been filed before your I-94 expired. That is very crucial. Now, this concurrent filing doesn't have to be filed when the I-94, even if this concurrent filing can be filed after the I-94 expires. However, if the application of the extension or transfer, either of those things gets denied, then you have to stop working for the concurrent filing H1B immediately. You can't just work because your I-94 expired, so you can't work for the concurrent file H1B.
Fanny from YouTube recently got an H1B approved, and his wife's H4 is still pending due to the biometrics, but her I-94 expires next week. He wants to know if she will be legally in the country after her I-94 expires. Yes, there is a specific provision. If you have timely filed an extension of status, which she did on that I-539 application, then she's in a period of authorized stay, meaning she's legally allowed to remain in the country while that extension is pending, even after her I-94 expires.
One second.
Sanjana from Facebook wants to know if a candidate on an initial OPT can work as an independent contractor. Yes, that is possible during the first 12 months of OPT. It's not possible during the STEM extension.
Ujjwal has this question, Emily. It's the priority date for the EB1 has moved by 10 months. Do you expect the same kind of movements going forward? Maybe not. Here is the reason. They moved from 2015 to 2016. Not many applicants were pending between that period of time, though. However, we do have a suspicion that starting from October, though, there is a chance of EB1s moving very fast. But that should be starting from October 1st of 2020, not right now. Because of all the COVID situation, the family preference categories may not get used. Those that don't get used should fall into the employment-based category. So there may be some movement starting from October 1st. But from now to October, we're not, even though you see that there is a 10 months movement, it's 2015 to 2016. Not many people are there between that period of time. If they were there, they should have been filed the adjustment of status and might have got the green card long time ago. So the people who are waiting between EB1, between 2015 and 2016, are very less people. That's the reason they moved from 2015 to 2016, a 10 months movement. Don't expect that, going every month, it's going to be 10 months, 10 months, it's going to be current in the 4 months. Do not expect that.
Satish from YouTube wants to know if there's a new definition of specialty occupation. No, that's what's been so interesting since the Trump administration came in. There's been no changes in the regulations or in the law for what is considered a specialty occupation. the interpretation of the existing definition has changed to where they're looking at it more closely and denying more petitions under that reason. But what it's important to know is they don't look at the title of the position alone. They look at the job duties that are listed. Do those job duties sound complex enough to require at least a bachelor's degree in a specific field of study? They look at what occupation category was selected for the LCA. They look at the wage level. All of those things help them decide whether it's a specialty occupation or not.
Anything else, Emily?
I think we're out of time for today. If we didn't get to your question, you can always join one of our daily conference calls. Go to rnlawgroup.com to get the schedule and dial in information for that. And we're still offering our discounted consultation fees. So you can go to rnlawgroup.com to set up a consultation with us or any of our attorneys at Reddy and Neumann.
Thank you guys for coming in.